Hello and welcome to California Gun Law. I'm your host, Don Hammond, with another update on California magazine law. Standard capacity magazines, that is, magazines that hold more than 10 rounds, are once again legal to possess in California for now. Let's take a look at the latest order from the Ninth Circuit Court of Appeals in the Duncan versus Bonta case and its practical impact. I'm a licensed California attorney and a shooting instructor. I regularly help teach the 16-hour class that's required to get a concealed carry license in California. On this program, we provide education on California's complicated web of gun laws so that responsible gun owners like you can better understand how to lawfully exercise their rights. California has a complicated web of firearm laws and regulations, and there are a lot of traps for the unwary. We want to help you do it right so you won't need our criminal defense legal services. Today, I'll discuss the latest legal status of standard capacity magazines. A standard capacity magazine, which California calls a large capacity magazine, is any magazine that is capable of holding more than 10 rounds of ammunition. The bottom line is that old magazines and Freedom Week magazines are still legal to possess in California as of today. It is, however, not legal to manufacture, import, buy, sell, lend, give, or receive these magazines that hold more than 10 rounds. The newest change comes from the Ninth Circuit in the Duncan versus Bonta case. I know, we just talked about that a few weeks ago, right? On April 10th, 2025, the court issued a limited stay of its March 20th decision in the case. In the March 20th decision, the court upheld California's magazine ban in its entirety, finding that a magazine is an accessory rather than an essential component of a firearm. Consequently, the court held that magazines are not protected by the Second Amendment and that states can regulate the possession of those accessories. The law at issue is California Penal Code Section 32310. Part of that section also requires people who are in possession of such magazines to get rid of them, either by sending them out of state, selling them to an FFL, or by turning them in at a local police station. That's the part that is once again on hold. On April 10th, the Ninth Circuit granted a limited stay prohibiting enforcement of the part of the law that requires people to get rid of their magazines that they otherwise lawfully possessed. Interestingly, the California DOJ didn't even oppose this stay while we see what the Supreme Court's going to do. These are magazines that people had before the magazine ban took effect or that people acquired during Freedom Week. After the March 20th decision, we were advising people to stop carrying their standard capacity magazines to avoid the possibility of being charged. Now, it's safe to carry them again. The government would have to prove beyond a reasonable doubt that you acquired these magazines while they were banned. That's pretty difficult for them to do. And they may have trouble showing that the statute of limitations has not expired. In other words, they would have to convince a judge that you acquired or manufactured the magazines within the last 3 years before they charge you. So you still may have to be careful about carrying magazines that didn't exist during Freedom Week in 2019. Magazines for newer models of handguns, for example, may still be risky to carry. Freedom Week was the last time that a California resident could legally acquire a magazine that holds more than 10 rounds. That was March 29, 2019 through April 5, 2019. It was a time when a lower court had found in favor of gun owners before the appellate court placed a stay on that decision. That legal maneuvering happened in the very same case that we're talking about today, Duncan versus Bonta, and it's not over yet. The limited stay from April 10th is valid for 90 days to give the plaintiffs a chance to file a petition for writ of certiorari to the United States Supreme Court. The stay says the mandate is stayed for 90 days from the date that this order is filed, that was April 10th, if within that period the clerk of the Supreme Court advises the clerk of this court that a petition for writ of certiorari has been filed, then the mandate shall be further stayed until final disposition of the matter by the Supreme Court. So to extend the stay, the plaintiffs need only file their petition for review in the Supreme Court. Then we'll be legal to possess our magazines until the Supreme Court makes its final decision. That may be a decision to deny review, meaning that the court may reject the case and let the Ninth Circuit's decision stand. Or the Supreme Court may accept the case, set a briefing schedule, allow oral argument, and then finally issue a decision. If the court accepts the case, then a final decision would likely be at least a year, more likely about 2 years away. This case, Duncan versus Bonta, has been ongoing since July of 2017. Our friends at CRPA have been doing a great job of fighting every step of the way. This case is in a good position for the Supreme Court to accept it. The court has been denying cert in cases that are not final. That is, they are still in the preliminary injunction or interlocutory appeal phases of the case. Duncan is different because it is a final decision, and a published decision at that. So it's a good candidate for the Supreme Court to take up. The Ninth Circuit is the most often reversed appellate court when the cases get to the Supreme Court, so we're optimistic for gun owners on this one. We'll keep an eye on further developments, but for now, I'm putting my standard capacity magazines back in my carry guns. I'm Don Hammond at California Gun Law, and we'll catch you all next time. Stay informed, stay legal, stay safe.